I'm Ron Miller. I'm a personal injury attorney in Maryland. In this video, I'm going to talk about the trial and settlement value of slip and fall cases in Maryland. My firm has handled countless premises liability cases against property owners. We've made millions of dollars for our clients. Premises liability cases are commonly referred to as slip and fall because the customer is slipping or falling on a wet surface. That's sort of the prototypical premises liability case. However, premises liability cases involve much more than a simple slip and fall. Premises liability covers any situation in which a property owner fails to maintain their property in a safe condition and it results in someone getting hurt. This can involve things like a collapsing ceiling, lead paint, failure to provide security or adequate lighting, and other things causing injuries to individuals on the premises. So how much are premises liability cases typically worth? Let's start by looking at some statistics. Reported verdicts and settlements indicate that about 68% of Maryland slip and fall cases had a value somewhere between $5,000 and $50,000. By contrast, about 5% of slip and fall cases in Maryland resulted in a final value above $500,000. The value of a Maryland slip and fall case will be driven by three primary factors. The first factor impacting the value of a slip and fall case will always be the nature and severity of the injuries. This is the big one. This is the level of injury, and it has the most impact on the value of the case, by far. A slip and fall case that results in minor injuries, such as a sprained wrist or some bruising, will naturally be worth much less than a case where someone slips and breaks a leg or worse. If you look at the notes to this video, I left some resources so you can see statistics and sample cases and verdicts and settlements involving your specific type of injury, which will help you, I think, a great deal. The second factor that dictates the potential value of a slip and fall case is the extent of the property owner's negligence and resulting liability. Even when a slip and fall results in a serious injury, this second factor can often render the case worthless in spite of the injuries. In most cases, the plaintiff must show that the property owner had actual or constructive knowledge of the hazardous condition in order to establish liability. For example, if a customer walks into a store and slips on a banana peel, they would need to prove that, one, the store owner or employees actually knew or under the circumstances should have known about the banana peel. If the plaintiff cannot prove this notice, the case would be worth nothing. Liability is much easier in cases where the hazardous condition was actually created by the property owner or its employees. The classic example of this is when the employee mops the storeroom floor. In this case, the plaintiff does not have to prove actual or constructive knowledge of the wet floor. The property owner is the one who made the floor wet, so the knowledge is presumed. The third and final factor in the evaluation of a slip and fall case is the jurisdiction where that lawsuit is filed. This factor is particularly important in Maryland, where slip and fall cases in plaintiff-friendly jurisdictions, such as Baltimore City and Prince George's County, are consistently worth more than comparable cases in other counties. Let me give you an example case that I tried. We had a case where a janitor in Baltimore injured her ankle in a fall in a trench at a school during a power outage at the school. What happened was an electrical contractor pulling wires out of a trench in the floor in the boys' bathroom, so they didn't cover the trench. The contractor at trial blamed everyone, claimed the victim should not have been there in the dark in the first place, and they even argued, get this, they argued she recovered slowly because she was overweight. They would not make anything resembling a reasonable settlement offer. So my partner Laura Zois and I took the case to trial. A Baltimore City jury awarded our client over $500,000. This was far more than our client wanted to resolve the case in the first place. I can't guarantee that result or any result in your case. What I can tell you is if we take your case, we will fight like crazy, like we did for this nice woman, to get you every last penny you deserve and then some. If you have a possible premises liability claim for a slip and fall or another hazard on the premises, call Miller & Zois today at 800-553-8082. Thank you.